So this means that at this point you are clear that there is going to be a dispute.
Yeah.
And at that point it's over to the lawyers.
Yeah.
Now, in Turkey, you don't have to use a lawyer, do you? You can go to court yourself without the services of a lawyer.
Yeah, you can. But it's very unusual.
You'd have to be insane. Even a Turkish person dealing with another Turkish person would use a lawyer to go to court.
Yeah.
And for an international person who doesn't speak Turkish to go to court without using a lawyer, just as you don't even want to think about it.
Yeah.
So at this point you have to contact a lawyer.
Yeah, because the court procedure in Turkey is, I think it's the same in all over the world. It's procedural.
Yes.
So you shouldn't make any mistakes on your procedure, because then you might lose your rights.
You might lose your rights, or at least you'd be delayed by months and months and months.
Exactly. So this is why actually, if a person needs to go to court, they usually go to a lawyer.
Yes. Now we have done another video about how to choose a lawyer, but I guess the important thing here is that almost every lawyer deals with civil litigation.
I would say.
There are some lawyers who don't deal with some things, but there's not many who don't deal with civil litigation, because that's right at the centre of the way lawyers perceive their
You
role.
might just face this. Some of the lawyers are just dealing with the criminal cases.
Yes.
They don't want to enter into the like civil like litigations or dispute. They don't want to deal with the contract. They just deal with the criminal cases.
Yes.
But other than those type of like law firms, I think more or less all of them are dealing with the civil cases.
Okay, so you find a lawyer. Do look at our video about how to choose a lawyer, because there are some important notes there as to how to find the best lawyer for your requirements. You find a lawyer, and the lawyer then has to deal with the case. And so if a client walked into your office today and said, I've got a problem with this person, he's not built my construction project properly, what sort of information would you require from your client?
Yeah, we would first ask, is there any written document between parties proving the relation and the conditions? That's going to be our constitution basically. And afterwards, we will be asking whether is there any correspondences between parties, either a notarized notification or emails, any proof. And we also have witness systems, so we will be asking, is there any witness who can help out to prove your claim? Afterwards, we will commence our investigation about the case, do our study. In some specific cases, which is involving technical knowledge, we are also going to a technical consultant and get an information, do our own research and get some feedback from them.
Let's just wind back a bit there. So the person, you're going to want to see all the paperwork, all the documentation. A client can save you a lot of trouble and himself a lot of money if they organise that before they come to see you. So to actually print off all of the stuff, put it in date sequence and give it you in an ordered way, rather than just bringing it in a big box and saying, there you are, there it is.
Yeah, because it is going to be very time consuming, otherwise they will just lose time and money.
And you'll be charging for that service. So do put things in order. Do you like to receive things in digital format as well as printed format? In other words, copies of Word documents on a disk, or do you just want the printed ones?
We don't actually, it doesn't matter. Either a digital or printed version is acceptable by us.
Okay. So you get information about the case by way of the documents, then what happens?
Then we study, and then we will be letting the client know about our action plan. And then if he's agreeing, because sometimes it might be a substantial cost involved, so he needs to agree about the process. We are letting.
So you give an estimate of costs.
Estimated cost. Once we receive the documentation, first we give the estimate of cost, and together with our proposed action plan.
Yes, and it's probably fair to say, isn't it, that no estimate of cost can ever be accurate here, because you don't know whether you're going to threaten this person and they're going to pay you whatever they need to pay you, or whether the case is going to go 4 years to the Court of Appeal.
Exactly. So we are providing all the options and the outcomes. So either a settlement version or a dispute version. So the client will know what they will be facing if they go for a dispute,
Yes.
in terms of like a cost and time involved. So once the action plan is agreed and the cost is agreed with the client, then we get the power of attorney, which is our starting point, really.
So again, we have a separate video about powers of attorney and a separate guide about powers of attorney. But this is the document that authorizes you to do things on the client's behalf.
Yeah, as a lawyer. So it is not very wide document as a context. It is only like authorizing us to act before the court and judicial system in terms of the legal affairs. So you are not providing like a sale of your immovables. Yeah, it is a very limited power just for actions for lawyers, and it cannot be used just a normal person. It can be only used by a lawyer.
Okay, so the person gives you power of attorney. You're probably going to want some money from them at that point to pay your expenses.
We are asking for on account of course some payment to cover the expenses, and also some part of our fees has to be paid upfront.
Yes. So with your power of attorney, you can then start the court case.
Yeah.